Okay, this is cause numbers 22-39100 and 22-39101. Are you Leticia Tibo? And Ms. Tibo is currently on probation for failure to comply with sex offender registration in each of these cases.
Right away, you can feel the judge slowing things down to double-check the paperwork. And trust me, in probation cases, details matter. One wrong sentencing term can completely change the outcome. The court is already signaling, we're not rushing this. That's usually a sign the judge is taking these violations very seriously.
I looked this up. I think there may be, and Ms. Simon's here, this update report says 2 10-year adjudicated probations, but it was a 2-year term.
It was 2 over 5.
2 TDC over 5, correct? Okay, just making sure. And so Ms. Tibo was previously here, entered pleas of true to counts 2 and 4 in the motion to revoke probation, and I've received the updated pre-sentence report. Have you all received that updated report? Any additions or corrections to that other than the one that I already made? And there was no agreement. Is there any evidence with regard to the other counts, Mr. Hoffpower?
Any new failed to register?
I don't know. She pled true to counts 2 and 4, so there's obviously some other counts. Do you have any witnesses or evidence with regard to those other counts?
We're going to full abandon those counts.
Okay.
Other than that, I can call my probation officer. I like her opinion.
Okay, so I guess there was an arrest in
It's in Florida.
Palatka, Florida. Okay. Hold on a second.
Putnam County.
Okay, so count 1. Why don't you have any evidence with regard to count 1 if your probation officer's here?
We can call. Sorry, apologize.
Ma'am, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
Please take that for the record.
Seriously.
I'm a son of you, the probation officer, Ms. Tibo. Okay, and how long have you been in the first?
Year and a half.
Okay, and throughout the time that you've been a probation officer, has you complied with the terms of either one of them?
Speak up, please. I'm sorry.
Okay, no, she has not.
She's not.
Yeah, okay, in what instances has she not complied?
Tibo has had consistent reporting habits. She's not paid towards her fees. And she lives with
Was she allowed, first of all, was she allowed through her probation in Texas to venture out of the state and be in the state? She wasn't allowed?
She was not.
Is she allowed?
Uh-oh, this is where the hearing starts going downhill fast for the defense. Leaving the state without permission while on sex offender probation. That's one of the biggest red flags a judge can hear. And notice how calm the probation officer is. She's not emotional, just factual. In court, that kind of testimony hits hard because it sounds credible and organized.
Through her reporting as a sex offender to move or go to the state. Is she allowed to leave the state?
No, I don't.
She pled true to that. Count 1 is that she has not reported since January 27th of 2025.
Is that true? No, she intermittently, or she isn't fully, she's been called from Scotland.
She is.
Okay, since that day.
Or like 90 days after that contact.
And since she reported since the time on which she was arrested.
She has not reported
Have you spoken to her at the jail?
at the hearing.
Right, did she give a reason for why she didn't report? At this time, that's what
Okay, I also would like to know, Ms. Simon, were you able to confirm in any way the arrest? Obviously, she's going to say she didn't do it, and that's okay, but if she was actually just, whether an arrest happened in Florida?
PC. But do you have a problem cause? You have a school office? Okay. For what crime was it?
There's two. I think one was theft and then obstruction by disguise from others.
It was all the same incident. What date did that occur? According to
June 29th.
and were both those committed while she
As
was
far as committed, Your Honor, I don't object to her listing evidence as far as an arrest. but
An arrest.
As far as the actual commission of the violent electric protocol.
did the allegation occur?
Yeah, the arrest.
The arrest occurred while she was on probation.
Let's just did something.
Correct.
And those haven't been resolved in your name.
Not now.
Can I proceed, Your Honor?
Yes.
She initially failed to report in January, is that right, 2025?
That was the last face-to-face contact I had.
January 2025. Then arrest June 29th of 2025. So February, March, April, May, June, 5 failures to report. And she went into absconder status March 2025.
Maybe April.
April.
Like 90 days.
90, so April 2025, she became an absconder. 2 months after that, she was arrested in Florida, is that right?
Right.
So you were aware she was in Florida, what state? When were you made aware that she was in custody?
I received a phone call.
So let's break this timeline down because it's brutal. She stops reporting, disappears for months, becomes what they call an absconder, and then gets arrested in another state. From the judge's perspective, that paints a picture of someone completely avoiding supervision. At this point, the courtroom tension is basically screaming one question: is probation even salvageable anymore?
Somebody that let me know that she was arrested and in jail in Florida. And then that's when I obtained this first report.
So when there was an MTRP entered into NCIC, yes, after April, was there an MTRP, and that's why Florida advised you there was an active warrant about that?
There was an active warrant for the MTRP. She was arrested for these.
Right, and that warrant popped up in June in Florida.
Correct.
So from June 29th to today, she's still in custody, is that right? So she couldn't report
It just started doing stuff.
to probation. She's in custody from June 29th to today. So that's not her fault. She can't.
Correct.
As far as supervising her, she has reported, you say inconsistently, that means she has reported some, correct?
Correct.
During the times that she has reported, have you been able to interact with her appropriately? She maintained proper demeanor, that type of thing?
She was, yes, and she was consistently late. I had to reschedule her several different times to get her.
Have you had any other difficulties with her as far as just perhaps being late with scheduling, as far as your actual interactions? She maintained appropriate demeanor, acted appropriately with you?
Yes.
Would you object to continuing the supervision? Why is that?
My personal opinion, I don't think it's supervised for probation as a priority. She is on probation until 2022, and that's making progress with regards to her fees. She did some community service.
When you say progress, how do you measure progress?
Satisfying her full obligations.
And how she felt as far
And she committed.
So is this correct in the, hold on a second, hold on. Is in the updated report, it states that since she was granted supervision, has reported 6 times for scheduled office visits. Is that a correct number? Okay. 6 times since 2022.
I have another question, Your Honor.
Let's let Mr. Kimler finish.
If she were to be
Did you catch that? 6 office visits since 2022. That number landed like a bomb in this courtroom. Probation is basically a second chance contract with the court, and judges expect effort. The defense is trying to argue potential and rehabilitation, but the prosecution is hammering consistency. And consistency usually wins these hearings.
extended, which the court has the power to do, I mean, you would continue to supervise her, right? You have a problem with supervising her.
I would work for this.
See the indication of the need for some type of mental health. I mean, I understand she's not reported 6 times as a judge. You see kind of programs or other things that probation could do for her, maybe perhaps to get her on the right track.
I think the only other option would be to cognitive testifies.
Pass witness.
Your Honor, this is the first time that we've been here on these 2 cases for motion removal. There was another time back in 2024 in which we had a hearing similar to this, not me, especially as an attorney, but she was brought in on a motion removal, and her probation was amended, and she was given 30 days in JCC, and she was continued, and she was added to the mental health case.
No, I mean, in my case, because she didn't report enough to be transferred over to the high case.
So this is not even the first time that we've been here on this on similar allegations. That was a year in 2024. We did the same deal. Is that correct?
I might follow up on that. I believe in the previous NQRP, she had a motion, they gave a motion to vote. She had federal charges, is that right?
Correct.
The NQRP was filed after she received federal charges.
I believe so.
She was salaried to be supervising her.
That was her.
You know, the detainer was placed under the NQRP while she was in federal custody. Did she actually do federal time while she was on probation for this case?
That is why the NTB was dismissed.
So she received, I think, about a year sentence in federal court for misprision by felony. Is that consistent?
1 year federal probation.
Prison, she's locked up, right?
She got probation.
She had 1 year federal probation.
Probation for misprision? Or you know, what the offense was?
I thought it was a possession.
Anyway, she received a year of federal probation, so she was not revoked and was allowed to serve the probation she was earned.
Correct.
So during the period that she was on federal probation for that year, we know that she was reporting for federal probation officer with any issues with the federal probation she was on.
According to the CBO, she successfully completed.
And that was at the same time that she was on probation with Jackson County.
Correct.
Was she reporting to you during that time period as well? What was her reporting record in Jefferson County during that period? You said it's probably back in 2024.
Well, she's reported 6 whole times. So obviously it wasn't great even when it was then.
But she was being supervised at least during that period federally. Does that indicate to you that perhaps she was assistant with Jefferson County probation?
She has the ability to, whether or not she has the motivation, want to do something.
That's what.
All right, any other questions?
No, Your Honor.
All right, thank you, Ms. Simon. Any other witnesses?
No, Your Honor.
I would defer to Ms. Tibo, Your Honor. She wanted to address the court. I think she has written to the court, and that letter's incorporated in the PSI.
I received it and read it. Anything else?
No, I mean, when I did fail to report it, sometimes I was hard to schedule. But a lot of it had to do with my mother being sick, and I brought my mother sick too, when I was with me multiple times. Because I didn't.
This is the emotional pivot of the hearing. You can hear the defendant trying to explain the chaos in her life, family illness, instability, personal struggles. And honestly, these moments are complicated because judges do understand hardship. But here's the problem, courts also expect communication. When someone disappears instead of working with probation officers, sympathy starts running out very quickly.
I wasn't able to just say where she was at. I brought her when I could. I mean, she's bouncing out, but at that time frame,
But I mean, we're talking about since 2022.
I was in
Or
a
20
federal facility for a year and a day.
Okay. All right. So here's the thing. I'm not even sure where this agreement came from and why I accepted it in the first place, because giving somebody the minimum of 2 on a probation, so I have really nothing to do hardly on this. But Ms. Tibo, I mean, you've been given every opportunity over the last 4 or 5 years to do everything you're supposed to on this probation, and you've refused to do that. You flat out refused, and everybody, we all have different issues that go along with parents and family members and things that go wrong. And instead of, I mean, it looks like, I think one of the things that concerns me the most is that you called June 2nd asking why the police went to your home. June 2nd you called. And so your probation officer said there's a warrant because of your violations on June 2nd. Then you went to Florida and got arrested for 2 new offenses without registering, without obviously telling anybody where you are and the type of probation you're on, the offense that you're on probation for. That's probably the number one thing that you should do. So flee in the state when you know that there is a warrant for your arrest. Gives me no reason to leave you on probation. Unfortunately, I think for me and for the community, the most I can do is 2 years, and so that's what I'm going to do.
And there it is, the moment the judge's mind is completely made up. Listen carefully to the wording, gives me no reason to leave you on probation. That sentence tells you everything. The judge isn't just punishing the violations, he's saying the court has lost confidence in her willingness to follow the rules. Once a judge reaches that conclusion, prison time becomes extremely hard to avoid.
I'm going to find, based on the evidence today, that counts 1 and 3 are true. So I'm going to find you entered your pleas of true to 2 and 4 freely and voluntarily. Find all 4 counts true. Find sufficient evidence to revoke your probation, and cause number 2239100, revoke your probation, sentence you to a term of 2 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 2239101, also find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You need to sign that, please. I'm handing you the trial court certification that shows there was no agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that, and he'll give you a copy of that as soon as y'all get it signed. Thank you for being here.
All my